WMAL presents Law Call with your host, Rick Fowler.
The Supreme Court has now ruled discrimination lawsuits may be easier to prove. I'm Rick Fowler. This Saturday at noon on WMAL's Law Call, attorneys Tom Coleman from Williams, Mullen, Clark & Dobbins representing employers and Leizer Goldsmith from the Goldsmith Law Firm representing employees will discuss discrimination in the workplace. Call in with your employment questions Saturday at noon on WMAL's Law Call.
Law Call, Saturdays at noon on WMAL.
You know, it's funny they should mention that program. We just happen to have, those two fellas you just heard about in that little announcement there, they just happen to be gracing our studio tonight here on WMAL. They will debut tomorrow on WMAL's Law Call program at noon, brought to you by 1-800-LAW-CALL. Now, among the reason we asked them in tonight, among the numerous decisions handed down by the U.S. Supreme Court over the past few weeks was this judgment regarding employment discrimination. And tonight we're going to see if we can get this explained and how it affects you in particular. And we'll also delve into other aspects of the employee-management relationship, such as harassment and contracts and wages and overtime. And if we haven't thought of something, I bet you have. And you may call us at 202-432-WMAL today. That's 202-432-9625. Pound 630 is a free call on cell 1. And we invite your calls at any time during the program tonight. Let's welcome, first of all, Leizer Goldsmith. Leizer, welcome here tonight.
Thank you, Charlie.
Leizer is the host of uslaw.com employment channel, which is on Alta Vista. Tell us where that is.
Well, you can go to www.uslaw.com, and then they have 6 or 7 different areas you can go into there, one of them being employment law, and I've been doing weekly columns for them. Including one you can check out right now about this very case we're going to be discussing.
Okay, good. And you have your own law firm, the Goldsmith Law Firm.
That's
right.
If
I was going to name a firm after, I'd name it the Warren Firm.
The Goldsmith is much better.
It is. I'm sure it is. Okay. Well, welcome here tonight. And you represent the employee side.
That's right.
All right. Our next customer here tonight, representing the management, ladies and gentlemen. See, Leizer is the jogger and the Metro rider. And Tom Coleman over here plays golf, just like Jack Nicklaus and those guys, right? Huh?
Well, like Nicklaus played today, I think.
Oh, is that right?
No, I wish.
Good, huh? He had an 82 today. That's rough for Jack. Well, welcome, Tom. From Williams, Mullen, Clark, and Dobbins tonight. Do you represent the management side?
Yes, the good guys.
Okay. You fellas getting along all right? Huh?
So far.
Okay, good.
We'll see.
All right. Now, tell me about, and either one of you, come fire right up here about this Supreme Court decision.
Let me start off, Charlie, if I might. It's really, it came down on, I believe, on Monday. And practically speaking, the import of this decision, it makes it easier for plaintiff employees and ex-employees in employment discrimination to get their cases before a jury. And, of course, that is not good news for our side of the table.
Sure. Okay.
Because, as you know, when the case gets before a jury, anything can happen.
Right. All right. And the employees must, they're going to love this, huh?
Well, we hope to love it. We think we're going to love it. The big question here is how do you prove a case of discrimination? Because what had been happening in the courts, particularly here in the Maryland and Virginia branches of the federal court system, has been that the courts have been saying that employees would have to show basically a confession by the employer that they had discriminated, which of course we all know never happens. This case reiterates what the Supreme Court said earlier, 7 years ago and prior to that, which is that employees can prove through all the circumstances that they've been discriminated against. So assuming that the case gets enforced the way it should be by the courts, it is a good day for employees.
What was the case that actually brought this before the Supreme Court?
Well, it involved a 57-year-old employee who was let go, allegedly, for not keeping accurate time records and indeed falsifying some records. And at the trial, he was able to show that, in fact, he kept accurate records, and the employer was either misinformed or intentionally fired him for the wrong reason.
What was the reason that the employer said that he fired him?
Well, the employer said that he had not kept accurate time records and indeed had falsified some records.
I see. Okay.
And that was the reason that the employer gave. The jury concluded that this was a pretext. And the Supreme Court said that in some cases, this being one of them, if a jury concludes that the employer has lied about the reasons for firing the employee, then that, coupled with establishing a prima facie case, which we'll get into in a little bit.
Yeah, I don't understand prima facie. I don't even understand pretext.
It's a lie.
Pretext is a plaintiff's lawyer's favorite word, because every time an employer gives a reason for its action, the plaintiff's lawyers will yell pretext. And in this case, the court said if you can establish that this is a pretext, that in and of itself is sufficient in some cases to award the decision to the plaintiff without establishing anything further.
How's this from the employee side here?
Well, what's really at issue here largely is the question of whether juries are going to be able to decide these intentional discrimination cases, or whether the decisions are going to be left to unelected judges. The Congress in 1991 passed the Civil Rights Act that was intended to allow for jury trials. But in fact, what's happened in many of the federal courts is that the courts have used a procedure known as summary judgment, which basically means throwing a case out as a kind of winnowing system to eliminate a lot of these cases from the courts.
Mm-hmm. So has this helped this decision this week? Or it sounds to me, I'm hearing that...
it depends on who you're rooting for, Charlie.
Yeah. It sounds like it's got more complicated here.
Well, from the point of view of the employee and really in general, it hasn't gotten any more complicated at all. Really what the court is saying is that the jury should decide whether there was discrimination or not.
Okay.
If there's a lot of evidence to suggest that there was discrimination, even if there's no statements or admissions or confessions by the employer where the employer is admitting to having discriminated. And that's the import of the case.
All right. Those of you who have questions and would like to join us here on WMAL, feel free at 202-432-9625. That's 202-432-WMAL. If you'd like further explanation of this particular decision by the U.S. Supreme Court earlier this week, or anything else having to do with employment law, for instance, any other kinds of discrimination, race, what, age, sure,
national origin, disability.
Right. Yeah. There are all sorts of bases for discrimination. In fact, I think in the District of Columbia, there's 14 or 15 what us lawyers call protected classes, which means because of certain characteristics, these groups or classes or individuals have protection under law. And one of the cases we may get to talk about later on is a person who filed a discrimination claim because of their personal appearance. They claim they were discharged because they were grossly overweight. I don't know whether we'll get to that case later or not, Charlie.
All right, and when we may have some cases right over the phone here tonight at 202-432-WMAL. Sexual harassment also comes up. Yes.
There is another aspect to the Supreme Court case which is worth noting also, because the court made a decision that will affect the lower courts also. I don't think we told you that there were actually statements in this case. The management official told this employee who had been with the company many years and who was over age 50, I don't remember the exact age, that he was too damn old to do the job and that he could have come over on the Mayflower.
Mm-hmm.
And many courts, including some of the courts here locally, have taken statements like that in similar cases and concluded that they were irrelevant to a determination of whether there was any discrimination that had occurred or not, usually because they would say that the statement was made at a different time and in a different place from when the final decision to terminate the employee or not to promote the employee was made.
Yeah.
Charlie, if I might pick up on that, I think this is a good lesson for employers in spite of what Leizer said. A jury that hears such remarks is going to immediately conclude that the employer had an illegal or a discriminatory motive for its actions. And I think what this leads employers to do is that they have to teach their supervisors and managers that that type of comment and remark is simply unacceptable in the workplace.